Privacy, confidentiality, and privilege are distinct concepts that are often important to victims of crime and to the advocates and attorneys who assist them. In this short training video, we will investigate each of these concepts before delving into ways in which those serving survivors can assist them in protecting their privacy-related rights. There are many definitions of privacy. Dictionary.com draws on notions of being apart or concealed, or free from unwanted intrusion into one's private life. Black's Law Dictionary similarly references the idea of freedom from public attention, intrusion, or interference. Lawyers have been wrestling with the concept of privacy for a long time, and a number of fairly well-known law reviews have provided additional attempts to define the notion of privacy as the right to be let alone, as the power to control or restrict the dissemination of personal information. And in one more recent article, the author notes that this idea of privacy isn't something that exists to elevate the interests of one person above the needs of society. Instead, privacy is something that is part of society and an idea that is embedded in our American life. There's a quote written by Justice Stewart in connection with a 1964 Supreme Court case that didn't focus on privacy. The case was about obscene material, but which intuitively works when thinking about privacy. As Justice Stewart observed, some ideas, much like privacy, are hard to define, but you know it when you see it. And when it comes to privacy, the boundaries of what each individual considers private might differ, but it is something that you know when you feel it has been violated. So in that vein, we're going to engage with an exercise to help us define and understand privacy and privacy preferences. Because it can often be helpful to think of privacy using a series of metaphors, this exercise will use the metaphor of a continuum. Privacy can be thought of as a continuum, and we are using the continuum of the rainbow spectrum in this graphic as a metaphor for how that works, with the red side of the spectrum representing the options least protective of privacy, and the purple side of the spectrum representing options most protective of privacy. Everything in the middle comes somewhere in between. We are going to read through different statements associated with privacy, beginning with the red and working our way to the purple. And as we read them, take a moment to think about where you would place yourself on this continuum. Which set of statements resonate most with you and with which you most identify? So let's start with the first one. Red. Pretty much every part of my life is open to sharing and discussion with others, even strangers. I have been told that I have no filter. Orange. I am comfortable sharing relatively sensitive or intimate details with strangers or those I have only recently met. I am sometimes told that others are surprised I so easily share so many aspects of my life. My Facebook, social media, or blog settings are set to public, and I am willing to share almost everything that way. Yellow. There are only some aspects of my life that I protect from public consumption. I carefully curate the information I choose to make public on social media, but I am comfortable sharing some information that way. I'm willing to speak candidly with almost anyone I meet about almost any topic, but there will be subjects I simply will not discuss with a stranger or someone I have only recently met. Green. I am comfortable sharing most things in my life with a decent number of friends and colleagues. I restrict some information for closer friends and family. My Facebook, social media, or blog settings are not public, and I may filter some of the information I share on social media only for a smaller audience. Light blue. It takes me a while to open up to others, and I'm selective when choosing those with whom I will share more private information about my life. You have to prove yourself before I'm willing to share sensitive or intimate information with you. Dark blue. I discuss sensitive or intimate topics with only a select few individuals in my life, and only those I have known for a very long time, or whom I am seeing in a professional capacity, such as mental health professionals. And purple. I do not discuss topics I consider to be private or share information that is sensitive or intimate with anyone, period. Take a moment and think where you would place yourself along this privacy continuum. With which color do you most align? You can pause the video to do that if that's helpful to you. So now that you've positioned yourself along the privacy continuum, there are a couple of questions to consider. Was it easy to figure out where, from the red on one end to the purple on the other end, you would place yourself? What considerations came to mind for you when you were thinking about this? Did you think about time, where you might place yourself now versus 5 years ago, 10 years ago? Did you consider the subject matter as well? You might identify much more closely with red if the topic matter is perhaps not as sensitive or personal. But if you're talking about super private or sensitive information, you might position yourself closer to purple. Context and subject matter can make a huge difference when talking about privacy. Now, instead of thinking where along the privacy spectrum you might place yourself, think about where you might want someone else to be on this spectrum if you were to share your information with them. How closely would you want or need them to safeguard potentially sensitive information? What color would you want them to align with respect to your sensitive information? Regardless of where you started along the continuum where it comes to your private or sensitive information, you may have moved closer to the purple end of the spectrum when it comes to someone else's care for your information. You may not choose, in the case of personal or sensitive information, to share that information with someone who's closer to the red end of the spectrum, who has no filter, and who will take away your control over your most sensitive information once it's disclosed to them. And then finally, think about what you know about your professional privacy obligations. What do your ethical obligations and your supervisors tell you about how protective you ought to be over information that is shared with you in your professional role? So even if you're personally a red, your professional privacy obligations may require you to be a purple when it comes to private information that is shared with you. In this video, we will take a closer look at some of these professional obligations, but first, we'll provide context for those obligations using another metaphor. We have just taken a look at the concept of privacy using the metaphor of a continuum and talked about varying preferences when it comes to the protection of privacy in different contexts. Now we're going to switch to another useful metaphor that will help us take a deeper dive into the concept of privacy and the different types of legal protections that apply to privacy. This metaphor is the privacy closet. The closet itself, the biggest rectangle in this metaphor, encompasses all of the things we just thought about in the rainbow privacy spectrum exercise. It's the informal, cultural, personal notion of privacy in general. We are going to start with this broadest lens before moving on to the specific legal protections of confidentiality and privilege that can apply to certain types of private information. And before we delve deeper into this metaphor, pause the video for a moment to think about and then write down characteristics that come to mind when you think of a closet, just a regular closet like one you would have in your home. Try to write down at least 5 different characteristics of closets. Once you have done that, please continue the video. A lot of things may come to mind when we think about what characteristics a closet might have, and you probably wrote some of these down. One common type of closet is the closet right after you enter a front door, which is often used as a coat closet, both for those who live in the home and for their guests. There's no lock on it, it's just an ordinary closet, and we often open this closet for others to offer them a place to store their belongings. We routinely welcome others to open and access this type of closet. Another type of closet is a closet that's used to store towels or spare sheets, blankets, and bedding. This type of closet is often not secured, but is generally located further inside the home. And unless an overnight guest has been shown where spare towels or blankets are, you generally wouldn't expect someone to go looking around in there. It would be pretty startling to see someone opening up this type of closet just to check out what's inside. It's a type of closet that people generally don't access without permission, even though there's nothing particularly sensitive stored inside. And some closets may be in even less trafficked areas of a home, such as a bedroom. And again, there may not be anything particularly sensitive in a bedroom closet, just shoes or clothes or whatever household items were corralled during a frantic pre-guest cleaning spree of your home. But if you found a guest poking around in your bedroom closet, it's unlikely that they'd be invited back. It feels really different because it's a more private area of the home. One thing that you might have identified is that most closets in a home aren't locked. They may be in more or less private areas of the home, and they may or may not even have doorknobs or something on them, but they generally aren't locked. We generally respect the boundaries of privacy based not on physical barriers to entry, but on the conventions of relationships and friendships and social expectations. Closets could contain sensitive information, but oftentimes they're simply a private space that may contain very little that's actually sensitive or really personal information. The final two components of our closet metaphor are the fire safe within the picture of the closet and a locking box inside the fire safe. People often keep things inside the fire safe that would be inconvenient to replace if there were to be a fire, birth certificates or passports, for example. And then there may be a little lockbox with its own key inside the fire safe, containing information in our metaphor that is even more private. So the little locked box with its own key is inside the locked fire safe inside the closet. Now that we've provided an overview of the components of the privacy closet metaphor, we're going to discuss how those components tie in with legal protections. The closet is the big frame, information someone would consider private in the colloquial sense, in the individual sense as it exists according to each person's preferences on the privacy continuum. A person can simply choose not to share information they consider within the privacy closet. They could shut the closet door, not allow entry to the room where the closet is, etc. And often unspoken convention, not necessarily law, governs respect for others' privacy. Confidentiality provides a level of legal protection beyond simply shutting the closet door on private information. This higher level of protection applies to safeguard what is often highly sensitive personal information. You can think of this information as being put into a metaphorical fire safe. What else do you notice about the confidentiality fire safe in the image? That's right, there's a lock and a key. Many victims will access services such as counseling, advocacy, or medical treatment in the aftermath of crime. In seeking such services, a victim will frequently open the closet and share highly sensitive personal information with professionals. When this information is particularly sensitive, the victim is keeping it in a fire safe within the closet. The victim is willing to give the professionals a key to the safe, but only on the condition that the professionals promise not to open the safe and provide access to the information to anyone else. The promise to hold in confidence the victim's information is governed by the professional's ethical duties, regulatory framework, and/or by other various laws, and breaking the promise may carry sanctions. The promise not to disclose information that is shared in confidence, as well as the legal framework that recognizes this promise, are what qualifies this information as confidential. Described another way, confidentiality is a legal and ethical duty not to disclose the victim client's information learned in confidence. When providing services, professionals must be careful not to mislead a victim about the level of protection provided to information designated as confidential. Although laws may explicitly prohibit disclosure, there are often exceptions that require disclosure in response to court orders or valid subpoenas. For example, a court may make a determination that other interests outweigh the victim's right to privacy and confidential information and order the professionals to turn over their key to the victim's safe. Although a victim can be assured that a professional may not ethically disclose their confidential information unless they're legally required to do so, it is important that a victim understand that courts have the authority to require a professional to break that promise of confidentiality if certain conditions are met. Professional confidentiality obligations can come from a number of sources, depending on which ethical codes govern your conduct in your role. Advocate ethics, social worker ethics, victim attorney ethics, medical provider ethics, or mental health counselor ethics. There are generally professional consequences for violating these obligations. For example, licenses may be revoked. Additional professional obligations to keep information confidential can be found in funding sources. Victims of Crime Act, VOCA, Violence Against Women Act, VAWA, and Family Violence Prevention and Services Act, FIPSA, for example, may each have confidentiality provisions that govern your professional conduct if your agency receives funding from those sources. And confidentiality obligations may be found in other laws as well. the Federal Educational Rights and Privacy Act, FERPA, the Health Insurance Portability and Accountability Act, HIPAA, and the Stored Communications Act are some examples that may operate to protect the confidentiality of certain information. Other examples, such as laws exempting victim information from disclosure under public records laws, or laws requiring that information relating to children involved in dependency proceedings be kept confidential, may also operate to protect private information. So it's important to research and understand all of the confidentiality laws that could apply in a specific situation. To review, in the simplest terms, confidentiality is a legal and/or professional ethical duty not to disclose victim-client information learned in confidence. Keep in mind that there can be exceptions to confidentiality obligations. In fact, there are two key exceptions. First, Brady disclosure obligations. Brady disclosures are required by the federal Constitution. Specifically, they obligate the prosecutor and others acting on the government's behalf in the case to provide the defense with exculpatory or impeachment information. The second key exception is comprised of mandatory reporting obligations, often in the context of children, the elderly, and people who fall into other vulnerable categories. Mandatory reporting obligations can be imposed on a range of professionals, from attorneys to advocates and teachers to mental health counselors and social workers. Mandatory reporting obligations require the reporting of certain information, often information that might indicate that a member of one of these vulnerable groups may be experiencing abuse or neglect. It's important to understand what exceptions, if any, apply to the confidentiality of communications you might have with survivors, so that you can explain them clearly in a way that allows victims to choose what they want to share with you. The third layer of the privacy closet is the lockbox located within the fire safe of confidentiality. What do you notice here? You will see that the lockbox has a lock, but no key to give to anyone else. Legislatures throughout the country have recognized that to be effective, some professions require even stronger legal protection of communications between the professional and the client than confidentiality alone can provide. This recognition has resulted in the passage of laws that prevent courts from forcing those professionals to break the promise of confidentiality, no matter how relevant the information is to the issues in the legal proceeding. This additional protection is a privilege, a legal right not to disclose certain information in court-like settings. Significantly, only the victim has a key to the privilege lockbox, and only the victim, as the holder of the privilege key, can waive the privilege and permit disclosure of their information. Privileged communications are specially protected, often by statute. Disclosure without permission is prohibited, and they are protected from disclosure in court and other legal proceedings. Some exceptions may apply, and privileges can be waived only by the holder of the privilege. What privileges have you heard of? Pause the video to write down as many privileges as you can that exist in your jurisdiction, and then once you have done that, go ahead and continue playing the video. Examples of privileges include the spousal privilege, the attorney-client privilege, the clergy-penitent privilege, the psychotherapist-counselor-patient privilege, the doctor-patient privilege, and the advocate-victim privilege. Many of these are common privileges that exist in most jurisdictions. The exception is the last one, the advocate-victim privilege. Not all jurisdictions have a victim-advocate privilege, and in those that do, the scope and strength of the privilege vary, so be sure to research the available privileges in your jurisdiction with a specific focus on learning more about any advocate privilege that may apply. In Oregon, for example, some community-based advocates may be able to claim privilege protections for their communications with victims, but there are some training requirements and other elements that have to be met before this privilege will apply. Let's take a look at an example of a victim advocate privilege. This example comes from Oregon Revised Statute, section 40.264. In this provision, victim is defined for purposes of the privilege as a person seeking certain services at a qualified victim services program related to domestic violence, sexual assault, or stalking. The privilege applies only to confidential communications with certified advocates in the course of safety planning, counseling, support, or advocacy services, as well as to records maintained or created in the course of providing services. In addition to discussing the requirements to become a certified advocate for purposes of the privilege, the law defines Qualified Victim Services Program. The bottom line is that this sounds complicated, and it often can be. Determining whether a communication falls within a privilege may not always be a simple analysis. In review, privilege is a legal right not to disclose or to prevent the disclosure of certain information in connection with court and other court-like proceedings. When it comes to the function of confidentiality and privilege protections in practice, on a day-to-day basis, confidentiality obligations govern your interactions and conduct. Privilege comes into play when trying to protect against disclosures in criminal or civil court, administrative proceedings, school disciplinary proceedings, and other court-like settings. It's important not to forget that while we often place a lot of emphasis on preserving victims' privacy, what we are preserving is a victim's choice, whether, what, when, and with whom to share their information. Victims may legitimately choose to share their information with anyone they want. As we discussed in the privacy continuum exercise earlier, everyone will have different preferences when it comes to sharing their information. They may also have other interests at stake that they prioritize over their privacy. It's critical to have a thorough discussion about the consequences of any disclosure, so that if and when a victim asks you to share information on their behalf, that decision is an informed choice. It's also important to adhere to any documentation guidelines and office policies that may apply to you in your role. One such policy may be using a release of information form to guide a discussion with the survivor and document their consent before information can be shared. Many positions receiving certain types of funding require that a discussion be had with the victim about potential consequences of releasing information, as well as requiring written and time-limited permission before any personally identifying information can be shared. These release of information forms should contain the specific information that is to be released or shared, the agency or individual with whom the information will be shared, the purpose of the release, the duration of the release and that it be reasonably time-limited, the date the release is signed, a statement acknowledging that the victim has read and understood the consequences of authorizing release, and a statement that the victim may revoke their consent, and ideally, instructions about how to go about doing this. And before we leave the metaphor of the privacy closet, let's take a look at how it might appear in practice. Imagine for a moment that a good friend of yours comes to you and tells you that they are getting a divorce. Now, there's no law saying you can't share that information with others. You'd just be a really horrible friend if you did. You'd be violating the conventions of privacy that are expected between friends, and you may lose trust, or even your friend. Now imagine that you are a victim advocate with a professional obligation to keep information private. And now imagine that it's not your good friend who comes to you, but instead it's a victim who tells you that they are getting a divorce because their spouse has repeatedly engaged in acts of domestic violence. Now your professional ethics and professional obligations say that you can't share that information with others. Unless you have some sort of mandatory disclosure or mandatory reporting obligation that applies, you must keep that information confidential, and you can't share it without the permission of the victim. And there can be negative professional and financial consequences if you do. Now say that same victim would like the support of a mental health therapist or their own attorney, or someone else who can claim that extra layer of privilege protection. Their communications with those professionals would benefit from additional privilege protections if someone is trying to gain access to them in a court-like setting. So let's take a quick look at a cartoon illustrating differently how privacy protections may work in practice. Victims of crime in jurisdictions around the country are guaranteed a number of constitutional and statutory rights. Rights to privacy are often included among these rights. Privacy rights can take many different forms. There may be a right specific to victims of crime, guaranteeing their privacy in connection with criminal and juvenile justice proceedings. There could be a right to refuse discovery requests for the victim's private information more specifically. There might be rights that apply to safeguard certain types of information. And there might be a broad privacy right embedded in the jurisdiction's laws that safeguards privacy in contexts not limited to victims of crime. Often, jurisdictions offer a combination of these options. Privacy rights might be explicitly written out, word for word, in a constitution, a statute, or a rule, or they might be found in case law. In addition to state constitutional rights to privacy and both state and federal statutory rights to privacy, the federal Constitution also provides privacy protections that can help safeguard victim privacy. In fact, many victims find privacy-related issues to be something they're quite concerned about. For many victims, privacy is like oxygen. It is a pervasive, consistent need at every step of recovery. Within the context of the legal system, if a victim is without privacy, all other remedies are moot. Privacy concerns can take many forms. A survivor might be worried about having their name or other identifying information become part of the official record in a case or make its way online, where details about their circumstances could become more widely known. A survivor might receive a subpoena for their mental health records, their diary, or other information. A victim might want as much information as possible about how private their communications with various professionals are, including their advocate, their attorney, or even the prosecutor. Or a victim might have safety concerns or other related concerns that require them to be able to protect their privacy as vigorously as possible. And these are just a few examples. When it comes to protecting privacy, victim advocates and victims' rights attorneys can help ensure that survivors understand their privacy rights and options, and that their rights are enforced when a victim's privacy is threatened. Victim advocates can explain the protections that exist to safeguard privacy and help victims understand what some of their options are. And they can help connect victims with victims' rights attorneys, who are able to provide legal advice to survivors and who can file papers with the court to help ensure that victims' rights are honored and enforced when the victim's privacy is threatened in connection with a criminal proceeding. Victims often have privacy protections that exist in law beyond confidentiality and privilege. Depending on the jurisdiction and circumstances, victims' privacy rights can be found in the federal constitution, in state constitutions, and also in both federal and state statutes and rules. These privacy rights often intersect with other rights guaranteed to victims, including rights to notice, rights to be treated with fairness, respect, and dignity, rights to protection, and more. In some jurisdictions, including in Oregon, victims have an explicit right to refuse defense discovery requests, which is often a very important right in the context of privacy concerns. Privacy concerns are not limited to the context of communications with advocates, attorneys, and others. Privacy concerns can be implicated in police reports and charging documents, which may name the victim or include other locating or identifying information. Privacy can come up in the context of pretrial depositions or subpoenas for victim information. It can arise during cross-examination at trial, for example, if information protected by privilege guarantees or by rape shield laws is sought. Privacy can come up in the context of victim impact statements and the information a survivor chooses to share in that setting. It can be implicated by requests for restitution, especially if a survivor provides invoices, bills, or other documentation in support of the restitution, as those may contain private victim information. And privacy can be implicated by public records requests, media access to or coverage of proceedings, and even by open courtrooms. Victims or their service providers can receive subpoenas, which are legal documents that ask for certain information. These subpoenas can ask for many types of information: medical records, educational records, counseling records, diaries, emails, social media information, cell phone records, cell phones themselves, internet search histories, and more. Subpoenas can be sought by defendants and prosecutors in criminal cases. Subpoenas can be thought of as a request for an order from the court for something, in this case for documents that someone wants to see. There can be legal challenges that can be raised before a victim or others are required to give anything to anyone in response to a subpoena. Formal discovery is a process that occurs between the parties in a criminal case, the state and the criminal defendant. The Brady disclosure obligations mentioned earlier, along with statutes and rules, require the parties in the case to exchange certain information with each other. Crime victims are not parties to the criminal case and do not have Brady obligations or other obligations to provide a criminal defendant with information. Victims' rights attorneys can be particularly helpful to a survivor if they receive a subpoena for their information in connection with a criminal case or if their privacy is otherwise threatened. Let's touch briefly on some legal tools that an attorney can use to protect privacy in these contexts. Key legal tools that victims' rights attorneys can use to safeguard survivor privacy include making motions to ensure the use of pseudonyms or initials instead of a victim's name, redacting and substituting documents to prevent the disclosure of victim information, filing documents under seal so they are not available to the public, or using protective orders to limit the dissemination of victim information, and filing motions to quash or motions in opposition to a subpoena for victim information. Motions to quash a subpoena for victims' private information are a powerful tool in safeguarding victim privacy and seeking enforcement of their rights. These motions draw on victims' constitutional and statutory rights and are most frequently filed by a victim's own attorney or by a prosecutor who is asserting the victim's rights on their behalf. Ultimately, every organization should have policies in place that clearly outline how requests for victim information, including by subpoena, should be handled. When it comes to subpoenas for information, sample policies and tips include: never disclose anything to the person serving or delivering a subpoena. Inform leadership of any subpoena immediately. Note how the subpoena was served, by whom, and to whom. Read the subpoena carefully and note who signed it. Note whether the subpoena is for records or for testimony, or for both. Note whether the subpoena is for a criminal, civil, dependency, or other proceeding. Find out whether the victim has given informed consent or would like to give informed consent to the release of that information. Identify potential legal representation to assist the organization, and identify potential legal referrals to assist the victim. There are also some prospective steps that can be taken in advance of any subpoenas to help safeguard a victim's privacy. For victims' rights attorneys, these include filing a notice of appearance to ensure that the court, the prosecutor, and the defense attorney all have formal notice that the victim has an attorney in the case and is asserting their rights. The notice of appearance can also be a convenient filing in which to formally request any victim's rights that require the victim to make a specific request for them. Another step that can be taken is reaching out to record holders, such as therapists' offices, a school, or any other location where victim information might be sought, to remind them not to disclose any victim information. You might also let these record holders know that the victim needs to be told of any subpoenas they might receive, as sometimes subpoenas are sent directly to a record holder without any notice to the victim that their records are being sought. But perhaps the most important step is the one often taken by victim advocates early on in the process, letting victims know that they have privacy rights and helping them form a plan about what they will do and who they might contact, including providing referrals to victims' rights attorneys, if they learn that the prosecutor or the defendant is trying to get a hold of their private information. Bottom line, privacy is a complicated topic. Privacy should be an ongoing topic of discussion both within the offices of victim services professionals and with the survivors we serve. If you would like to continue learning more about privacy, additional resources are available both on NCVLI's website, ncvli.org, and on the website of our membership organization, the National Alliance of Victims' Rights Attorneys and Advocates, NAVRA, at navra.org. On NCVLI's website, you can explore a range of additional free resources, including a number of in-depth articles in NCVLI's Victim Law Library. You can also visit our website to request additional technical assistance and trainings on victims' rights-related topics.